In Second Amendment news, a federal ban on selling handguns to 18 to 20-year-olds has been ruled to be unconstitutional by a district judge, bringing some challenge to this long-standing law. So under federal law, it's illegal for an 18 to 20-year-old to purchase a handgun, but not illegal for them to possess a handgun. So you can acquire a handgun as an 18 to 20-year-old, for example, by it being gifted to you, but you can't go out and buy one in your own right. So this seems a little strange, but that's the way the law is right now. And anyways, the court has looked at this and said, that doesn't make much sense maybe because, well, now that there's a Second Amendment right that applies to citizens of the United States, and, thanks to the Constitution, the citizens of the United States include at least the 18-year-olds, maybe they should be allowed to have handguns too. So let's learn a little bit more about this discussion. A federal judge said on Wednesday that federal prohibitions on dealers selling handguns to 18, 20-year-olds are unconstitutional. The U.S. District Judge for the Eastern District of Virginia said under the test laid out by the United States Supreme Court, these regulations would run afoul of the Second Amendment because that seems fairly logical. Because the statutes and regulations in question are not consistent with history and tradition, which is the task the Supreme Court has set out for us, as we have learned recently in Bruen, history and tradition. So what is the history and tradition? Well, not this, so therefore they can't do that. Therefore, the lower courts have been looking into this issue and have been deciding to expand gun rights because, the Supreme Court has kind of said, maybe you should take it seriously for a change. That'd be nice. The Justice Department declined to comment, but of course, they're looking at the opportunity to appeal, which of course would go to the Fourth Circuit. My odds would be that they would likely reverse given recent precedent, but you never know because, of course, the law has changed since the courts have been hearing this stuff. So maybe the Fourth Circuit will look at it differently, but I wouldn't bank on it. There are also procedural questions about the case, of course, as well. In the opinion from the court, the judge concluded that 18 to 21-year-olds are part of the American political community, logical, because they're entitled to vote, thanks to the Constitution for that nice amendment, and they can, of course, enlist in the military, and thus would fall under the protections. So, not for the least of reasons that the 18 to 21-year-olds are, according to the Militia Act of 1792, part of the militia. They are part of the militia, merely by being men between 18 and 45, 17 and 45. They are part of the militia. So if the militia has a right to have firearms, then presumably these people do too. The court writing that if the court were to exclude the 18 to 21-year-olds, it would impose a limitation on the Second Amendment that is not consistent with other constitutional guarantees, which would certainly be true, right? 18 to 21-year-olds are guaranteed their full flight of all their rights that exist. The Constitution also applies to children, of course, as well, at least as it respects to governmental action. But, in this particular domain, then they are being treated differently than other people who have legal adulthood. Turning to the second part of the Supreme Court test, where the High Court said regulations could only be upheld if there were analogous regulations looking to the history, the court said that the government had not presented any evidence of age-based restrictions on purchase or sale of firearms from the colonial era, founding, or early republic. And therefore, due to the lack of analogous regulations that would permit a finding the founders considered age-based restrictions, then, not so much with the age-based restrictions. So this seems pretty logical. And also the 18 to 21-year-olds also can possess and buy long guns. They can buy rifles and shotguns, just not pistols. So it's a very odd restriction in the first place because you can, at 18, buy a rifle, including one of those scary assault rifles you hear so much about. You can buy an assault rifle. You can buy a shotgun. You just can't buy a pistol, even though pistols are the quintessential self-defense firearm because that is, used by most people for self-defense purposes for home protection. Obviously, not exclusively, but you go back to Heller, and they even have that language about it being the quintessential firearm. So, 18 to 21-year-olds can buy the shotguns and rifles, but can't buy the handguns. So that seems odd. And then you look at this in the constitutional sense, and you're like, yeah, what are the basis of the restrictions? That's also odd. Even before the 2022 Supreme Court ruling known as Bruen, The constitutionality of gun restrictions for older teenagers, which, I suppose 18, 19-year-olds is one way of describing it, was a flashpoint of firearms litigation, and federal courts had taken different approaches. Some courts had said, that there could be restrictions, and some courts not so much. But then, of course, in Bruen, the Supreme Court changed this by looking to history as the dominant test. In March, the 11th Circuit Court of Appeals that upheld a law that raised the minimum age to purchase a gun from 18 to 21. So that was the rule in the 11th Circuit, but of course, Virginia being in the 4th Circuit is not bound by that. In concluding the Florida ban was constitutional, the 11th Circuit pointed to similar restrictions that were in place around the mid-1800s, around time of the ratification of the 14th Amendment, which would extend Second Amendment protections to the states. So the 11th Circuit disagrees on the historical analysis. The judge in this case noted that he is dissenting from the 11th Circuit, but he can, because he's in a different circuit. He noted that because this case concerns federal restriction rather than state law, he was looking at gun regulations in place around the country when the Second Amendment was adopted. Whether the 11th Circuit has a sound rationale in relying on Reconstruction era regulations will be tested on appeal, he puts in a footnote. So presumably the relevant test is the law around the adoption of the Second Amendment, right? The 14th Amendment adopts the Bill of Rights against the states, but in case after case after case, the Supreme Court has made clear that what is being extended is the rights that existed historically, not some new version of it, because this was tested and has been argued about many times at the Supreme Court. All right. When we are applying the Constitution against the states, what does that mean, right? Is there a different First Amendment as it relates to states versus the federal government? Because the First Amendment only applied against the states starting from the 14th Amendment. So maybe what was being applied against the states was a 14th Amendment era version of the First Amendment rather than a 1790s version of the First Amendment. Maybe the change of understanding had been adopted along with the First Amendment. But the Supreme Court has rejected that time and time again. Every single time they've been asked about this, they've been rejected. It comes up every single time they do an incorporation case. Hey, maybe this time we should apply a different version of the Constitution to the states. And no, the Supreme Court has rejected this two-track argument many, many, many times. So presumably, and also rejected in the Second Amendment because it was argued about in Heller as well, or more to the point, McDonald, because McDonald case was, of course, the case that applied against the state. So in McDonald, this exact same argument was made about applying some different version of the Second Amendment to the states. And the Supreme Court said no. No, it's the same thing that applies against the federal government. So presumably, therefore, the relevant test for historical analysis is 1790, not the mid-19th century. So the 11th Circuit is probably wrong, therefore. In an earlier case in the 4th Circuit, dealing with federal regulations, the 4th Circuit said that, this would be fine. But of course, the Supreme Court has changed the standard in Bruen. So, yeah. A lawyer for the challengers said that they were pleased with the decision, even though it ensures that future buyers can purchase firearms in the federal system, one that includes background checks and other requirements. We expect the defendants will appeal. They sure will. Nevertheless, we remain optimistic the decision will be affirmed in due course. Well, I'm not sure how optimistic you should be on this, to be honest. I think the 4th Circuit will probably reverse you. But you never know, you might get lucky. And maybe the Supreme Court will take this up someday too. So we'll see how that develops. Thus, that brings us to the end of the discussion about the Second Amendment as it relates to handgun with ongoing cases on this issue. Should the 18 to 21-year-olds be allowed to buy handguns the same exact way they currently can buy rifles and shotguns through an FFL? And the federal government says no right now for some reason, but the courts looking at this have said, well, the relevant test is history, and there's no historical barriers. So sure. So you can see this kind of case developing. They will appeal to the 4th Circuit. If I were a betting man, the 4th Circuit will reverse, but we'll see. And someday, somewhere, maybe this will get to the U.S. Supreme Court. Who knows when? At least for a moment, that brings us to the end of discussion of this case.